everyone for having us. I'm going to start off briefly and then toss it over to Marette. We are both thrilled to be here today to talk to you about the new laws in 2021. Before everyone else got let into the Zoom, and it was just Marette and I and the board members, we were joking about all the books behind me, which I will admit to you are basically for show. I never open any of them. It just makes for a Zoom background because there's this thing called the internet. But what those are all of the laws that you all have to follow every day as California employers. Full stop. Every single one of them. And if you don't, ignorance of the law is never an excuse. So suffice to say, there are a lot of things that we need to be sure to do as California employers, and that list grows every year. 2021 is no exception. And so while most of our focus as California employers has been on, something happened. I think we're still good. Okay. My face moved, so I wasn't sure if I got lost. Has been on COVID and dealing with that. That is a thing, and we're going to talk about it, but all of the same laws still apply with the same effect. So we're going to go through what we've highlighted, what we think to be the most important laws that are coming into effect, mostly statutory law. Then I'm going to finish up with some case law that we think is important. We understand that not all of this will apply to all of you. That's the way this goes. We kind of had to make an educated guess based on the membership, geographic locations, what we thought might be best. But ask us questions. We ask that at least in the early stages, we steer clear of questions from the group. Just in the interest of time, we will have kind of a dedicated question and answer session later. And that's especially true, I think, during Marette's section in the beginning, because it's going to be really rapid fire. And so we're going to want to try to get through that and don't want to run into a situation where we spend 45 minutes on her stuff and then all of a sudden I've got to run through things at the end. So let's try to do that, but we will answer all of your questions, I promise. And we will also stay here as long as we can. And our contact information, as I think you have here, is on all of our slides. We're happy to speak with you anytime. So with that, I will turn it over to Marette and I'll be back with you in a bit.
Wonderful. Thank you, Ryan, and thank you to the best chamber ever. So we're going to get started, and there are a lot of new laws, certainly every year in California, as Ryan just mentioned. To give you a brief overview, I'm going to start with covering some of the new changes to leaves, meaning leaves of absence, some mandated reporting requirements that businesses will need to follow going forward related to pay data, diversity, so on and so forth. And there are a couple of other smaller pieces of legislation as well that have passed. So I'm going to kind of cover, a mix of different laws. Then we'll get into COVID-19 updates, notification requirements. I know everyone has been dealing with so much related to COVID. On top of that, we have a lot of new laws. And then Ryan will also be covering the wage and hour update, updates related to AB5, independent contractor issues, and then we'll finish with a discussion of California case law and some new cases that came out last year and how they might affect you. Next slide, please. All right, so to start, I'm gonna discuss the California Family Rights Act, also called CFRA, so I'll go back and forth. A lot of you probably already aware of it. CFRA is what provides job protected leave in the state of California, and it's just one form of leave, but it provides 12 work weeks of unpaid leave in any 12-month period. It's kind of the state counterpart to FMLA. A lot of you may already know this. And again, what makes it unique is that it's job protected, meaning when an employee returns from CFRA leave, they're entitled to return with no less seniority. So they're either the same position or a roughly equivalent position is what they should be returning to. Now, SB 1383 is the new law that was signed into law last month. Yeah, same slide, thank you. So a few new changes effective January 1st of this year. CFRA now is going to cover employers that are much smaller. There are going to be new reasons that employees can elect to take CFRA leave, unpaid yet job protected. And there could be some issues with overlapping leave with different types of leave laws like the federal FMLA. So I'll get into some of these nuances in the next slide. All right, so before, under CFRA, an employee had to have worked for a company, business, for 1,250 hours in the 12-month period immediately preceding the request for leave, and had to have worked within 75 miles of the work site. Now, effective January 1st, there's no requirement that the employee work within 75 miles of the work site. So it's kind of broader. An employee could be working anywhere within California, teleworking, and they could be eligible for this leave. Another change that was made was previously, CIFRA was intended for employers with 50 or more employees, like the federal FMLA legislation. Now, effective January 1st, any employer that has 5 or more employees is covered by CIFRA, meaning you have to offer CIFRA leave to an eligible employee if they qualify. And when I say you have to offer, a nuance of CIFRA is that you have to give notice to the employee. So sometimes, even if they don't affirmatively come to you and say, hey, I think I'm eligible for this CIFRA leave under California law, which is unpaid, but means I can come back to the same position, employers also have an affirmative obligation to notify the employee that they're eligible for this leave. So the law says reasonable advance notice is what's required. Okay, we can go to the next slide. So reasons for leave. And this is one of the bigger changes to CIFRA that's starting this year. Previously, letter A, leave for reason of the birth of a child of the employee, the placement of a child with an employee in connection with the adoption or foster care of the child by the employee, or the serious health condition of a child of the employee. So that qualifying reason is still applicable today. However, the definition of a child has expanded, and I'll get into that. Letter B, previously, you're entitled to take CIFRA leave to care for a parent or a spouse that has a serious health condition. Today, there are much broader reasons for being eligible to take CIFRA leave. So an employee for a business with 5 or more employees can say, I need to take care of a child, parent, grandparent, grandchild, sibling, spouse, or domestic partner who has a serious health condition. So as you can see, the eligibility requirements have expanded, so more folks could be eligible to request this leave now if you have 5 or more employees. The next element, letter C, leave because of the employee's own serious health condition that makes the employee unable to perform the functions of the position of that employee, except leave taken for disability on account of pregnancy, childbirth, or related medical conditions. There's kind of a lot there that I just read off, but essentially, an employee can request to take leave if they have their own serious health condition. And just to make you aware, the definition of serious health condition is inpatient care in a hospital, hospice, or residential healthcare facility, or getting continuing treatment or continuing supervision from a healthcare provider. Those are kind of what qualifies as a serious health condition. And again, this is just for CIFRA leave. California kind of has an alphabet soup of different types of leave that could overlap with this. So this is just specific to CIFRA. Next slide. Okay, and this is another new reason, which is going to be effective January 1st. Previously, CIFRA did not apply to folks who had an emergency or wanted leave related to a military exigency. Now the new law as of January 1st says an employee is entitled to take leave because of a qualifying exigency related to the covered active duty or call to covered active duty of an employee's spouse, domestic partner, child, or parent in the armed forces of the United States. So, you know, that could cover a lot more folks now. So that's something to be aware of. Next slide, please. Okay, as I previously mentioned, the definition of a child has changed. So previously, child meant just biological, adopted or foster child, stepchild, legal ward, or child of a person standing in local parentis who is either under 18 years of age or an adult dependent child. Now the new law has expanded to cover children of a domestic partner or of a person to whom the employee stands in local parentis. So again, expanded coverage being provided to employees. Next slide. Okay, some additional changes when it comes to baby bonding leave. So previously I mentioned how CIFRA can sometimes overlap with other types of leaves that employees are entitled to. Additionally, previously if you had 2 parents working at the same place with the same employer, both of them couldn't ask to take leave at the exact same time for baby bonding. but effective January 1st, the law says if both parents are employed by the same employer, each parent is permitted to take 12-week work weeks of unpaid job protected leave. So smaller employers, this is something to be aware of if you hire two parents, who may have this issue arise. Next slide, please. Okay. Previously, CFRA had an exception for high paid employees. So you could say, hey, you're earning a lot of money, maybe I'm a smaller business. This would cause me a serious and substantial economic injury if I have to give you this leave and then bring you back. It's going to be unexpected, interrupt my operations. Now, as of January 1st, there's no exception to say that you're not going to give someone leave under CFRA just because they're a high earner or in the top 10% of workers employed at your work site. So if you had that, old exception in the back of your mind, no longer applies, and the law's changed. All right. Last but not least, we have a mediation pilot program that's also going to be offered in conjunction with these new changes. As we've just covered, there are so many nuances and ways that the law has changed. Now, AB 1867 creates a new mediation pilot program for small employers through the Department of Fair Employment and Housing, as described in the government code. So if you're a smaller business with 5 to 19 employees, either you or the employees can request to mediate through the DFEH if the employee brings a claim saying, my employer didn't give me CFRA leave the way I was entitled to. So the way you would find out about that, as some of you may know, but hopefully you don't, an employee may file a notice of right, a complaint with the DFEH, and the DFEH would issue a right to sue notice, meaning, okay, you've fulfilled this checkbox, this administrative requirement, employee can go to bring a lawsuit against the business. This pilot program says, wait, if you're a small company, we're going to create this opportunity for you to try to reach a resolution without going to court and try to mediate any disputes related to this specific CFRA leave. So it's beneficial, and if you're a smaller business, good to know. As we know, California, there's a lot of laws that can be very litigious. So these small programs like this that could help small businesses are good to know about. To be repealed in 2024, we'll see, to be determined. Okay. Next slide. Okay, so in this slide, I referenced paid family leave. This isn't a type of leave, meaning it lets the employee leave and then you have to bring them back. This refers to an income replacement benefit. So it's a little bit separate, but just wanted to flag for folks, some employees, if they just, elect to take CFRA leave, they may be eligible to get income replacement through paid family leave. And I just wanted to flag that just like CFRA leave now provides the opportunity for workers who have a military exigency to take leave, an employee can also elect to apply to receive paid family leave income benefits through the EDD. Okay, next slide. Another new law. I know we have a lot here, so please take down your questions and we'll get to them at the end. Kin care designation, new statute that's going to be revising Labor Code Section 233. Essentially what this new change to the law does is if an employee wants to take time off work, they're allowed to designate whether it's going to be their own sick leave or leave to care for a family member, which may allow them to qualify for CFRA or another type of leave. So essentially what this new change in the law does is say the employee gets to choose what type of leave they're taking. So if you have, strict policies about what type of leave an employee wants to take or not take, just be aware of this. And the information's on the slide. I can read it off in case that would be beneficial, but basically the new law is saying an employer shall not deny an employee the right to use sick leave or discharge, threaten to discharge, demote, suspend, or in any manner discriminate against an employee for using or attempting to exercise the right to use sick leave to attend to an illness or the preventative care of a family member or for any reason specified in subdivision A of section 246.5. So something to be aware of. section. Thank you. Okay, another new law that recently was passed, mandated reporting requirements for HR professionals. And this one's a bit more serious because it's revising the California Penal Code. So effective January 1st, 2021, AB 1963 is amending the Child Abuse and Neglect Reporting Act. What it does is it's adding human resource employees of businesses with 5 or more employees that employ minors to the list of mandated reporters. Additionally, any adult whose duties require direct contact and supervision of minors in the workplace, of the minor's duties in the workplace, and again, this is for businesses with 5 or more employees, that person is also a mandated reporter. So that means if you have reason to suspect or know of any child abuse and you're an HR employee at a small business, or you're an adult who supervises a minor in the workplace, you should be aware that now you have this affirmative obligation to actually make a report when these issues arise. And failure to report anything will lead to either jail time or a fine. So, important update here. Next slide, please. I see we have a question here. I'll be sure to address this at the end. Employees and volunteers. Okay, we'll get to this at the end. Thank you for the question. Pay data reporting. We have a lot to get through. So SB 973, Codified Government Code Section 12999 applies to private employers of 100 or more employees who are required to file an annual employer information report. And that's a federal report that bigger businesses are usually required to submit every year. So now a covered employer has to submit pay data to the DFEH by March 31st, 2021, and every year thereafter. And again, this is applying to bigger businesses with 100 or more employees. It's a lot of data that's going to be required to be reported. So I'm going to start with the first sub bullet point here. These bigger employers will need to report the number of employees by race, ethnicity, and sex in at least certain specified job categories and according to the pay bands from the US Bureau of Labor Statistics. And they're going to have to look at the W-2 total earnings within the reporting year, which is a calendar year, to determine this information. I know, again, it's a lot of information, but to try to break things down a little bit, when we say job categories, I have a separate list here I'll read off. So job categories refers to executive or senior level officials and managers, mid-level officials, professionals, technicians, sales workers, administrative support workers, craft workers, operatives, laborers and helpers, and service workers. So bigger employers will need to go through each of these categories, figure out how many people are employed, how much money they make, what is the race, ethnicity, and sex. The next thing that the employers will also need to do is create a snapshot, meaning look at all of this information from a single pay period between October 1st and December 31st of the year that they're making their report. And that'll be used to create the lists with all the other information. They'll need to report the total number of hours worked by each employee that's included in this report. And there needs to be a consolidated report for employers with multiple locations, including the employer's NAICS code, NAICS code. So employers can also include clarifying remarks at the end. And the purpose of this piece of legislation is to encourage employers to be more transparent, promote diversity. Some other things to keep in mind are the DFEH is aware of the administrative burden that this could require for some businesses. So they are going to offer templates on how to create this report on the DFEH website. So if you go there, they had a pretty helpful frequently asked questions page and also offered a template report for, well, I think the template report is coming. They're working on it. But because this March 31st deadline is coming up here pretty soon, you'll have the opportunity to see an example of what's expected to be provided. So I would encourage folks to go to the DFEH website to learn a bit more about what's going to be required in this pay data reporting. Next up, please. All right, some more reporting requirements. For publicly held corporations, the board of directors will have some diversity requirements. In prior years, there had already been diversity requirements related to various protected categories, but the latest update is that by December 31st of this year, 2021, publicly held corporations that are headquartered in California must do more to diversify their boards. And you can find this in the corporations code. So if you just Google corporations code, you can go to section 301.3b. No later than the close of the 2021 calendar year, a publicly held domestic or foreign corporation whose principal place of business or principal executive office, rather, according to the SEC 10K form, are located in California shall comply with the following requirements. And it lists off certain elements, pretty detailed. For example, I'll just read the first one. If its number of directors is six or more, the corporation shall have a minimum of 3 female directors, and so on and so forth. These requirements are pretty specific and detailed, so I would recommend that you try to go to the corporations code and review what's required. This may not be applicable for some, smaller businesses, but it's really also by business type. So if you're a publicly held corporation headquartered in California, I would recommend that you go to the corporations code and review what's required in terms of diversity. I can go to the next slide, please. So I just wanted to flag that there's a lot of requirements there. The next part of this, no later than the close of 2022, a publicly held domestic or foreign corporation shall comply with, additional requirements regarding having directors from underrepresented communities. So we're looking at both gender and underrepresented communities. And I don't have this definition on the slide, but I wanted to provide it. So when we talk about underrepresented community, that refers to anyone who self-identifies as Black, African American, Hispanic, Latino, Asian, Pacific Islander, Native American, Native Hawaiian, or Alaska Native, or who self-identifies as gay, lesbian, bisexual, or transgender. So there are a lot of requirements here. I would recommend that you take the time to look to see if this applies to you and what affirmative efforts you'll need to take to comply and avoid any penalties. Next slide, please. All right, other legislation. So I want to make sure we have enough time for Ryan here as well. There's a slew of additional legislation. I'm going to just kind of touch on them briefly. So the first one, SB 1384. This is for the labor commissioner. If there's a wage and hour claim brought by someone who says, I can't afford an attorney, or who's considered financially disabled, the labor commissioner can elect to sort of take on that claim and investigate it on their behalf. So I'm not sure this is going to affect folks too much, but just something to be aware of, new changes in the law. The next one is a bit more, good to keep in mind, at AB 3075. So this refers to successor liability for wage and hour judgments. What does this mean? If you have a business, someone has a business, and there's a wage and hour lawsuit, there's been violations, and then there's a judgment, an adverse judgment against the company. Just because you sell the company or someone else becomes an owner of the company, that liability for the judgment will continue regardless of how you tinker with the entity or whether the business is sold. So that is something to keep in mind. California is very strict when it comes to its wage and hour laws, and I definitely want to flag that for folks who are getting ready to sell a business or dealing with certain issues. And happy to discuss more in our Q&A session on that because we have a lot of notes. Next one I wanted to briefly mention, AB 1947. This just extends the period of time that an employee can bring a claim for a wage and hour issue to the labor commissioner. I believe previously they only had 6 months. I think now it's been extended to a year. So just more favorable for workers when there's wage and hour issues. Next piece of legislation, AB 1864. California is making more initiatives to promote consumer financial protection. So this establishes the Department of Financial Protection and Innovation. And you just kind of want to keep in mind that there are more consumer protection efforts that are ongoing. AB 2143 restricts the scope of settlements and employment disputes as stated in the Code of Civil Procedure, section 1002.5. To provide a little more explanation here, specifically it prohibits settlement agreement provisions that prevent the settling aggrieved person from obtaining future employment with the employer against which a claim was filed. So basically, if you have a settlement agreement, you can't slide in a provision at the end saying like, okay, you sued me, so you're never allowed to work here again because, you know, whatever reason, I have an issue with you, what have you. The barrier, you know, that's prohibited. And there's only limited circumstances where there are exceptions. Those nuances are sexual harassment cases or other cases where there's sort of documented evidence of a reason for which you would say, no, this person can't come back. So kind of want to be aware of that if you're dealing with a lawsuit or settling a claim with someone, especially for an employment matter. So that's it for now. Feel free to, let us know if you have questions at the end, and I'll pass the torch to Ryan. Thank you.
All right. Thank you, Marette. I want to make sure everyone can hear me before I get going. Anybody? Lee, I can see you as a thumbs up. Okay, perfect. Let's go. Again, thanks to Marette for, let me move my face here. Sorry. Okay. Thank you to Marette for all of that. As you all likely realized, rapid fire, right? There's a whole lot going on. And so, one theme that is common throughout our presentations here, as you've likely seen as you're seeing it, far wordier PowerPoints than we would normally do. I abhor PowerPoints. If we were in person, I'd have a bunch of pictures of puppies and stuff behind me, and we'd have a conversation. We can't do that in COVID. So we want to make sure, especially because these are new laws, we wanted to make sure that you have something to take home. So it's intentional. If you either have or will have access to these slides, we'll make sure that we'll get those over to the folks at the chamber and distribute and do with them as you wish. So COVID-19 update. Things are changing, right? Not just in terms of how the world is in numbers and all of that, but legislation. The FFCRA phased out on December 31st. So technically it is an optional thing right now, but we're not required to abide by the FFCRA. That's the Families First Coronavirus Response Act. Hopefully that's not a new term for you. What is very likely to happen, and why I'm not going to talk much about it, is we're likely to see something new with the new administration that was just sworn in yesterday. We just don't know exactly what it is. It wasn't on the list of President Biden's first day enactments, but it's kind of been a promise for the first days. So stay tuned for that. We may be a couple days short on what we might be able to do with that. As things come out, we have lots of newsletters and stuff, so feel free to reach out to us, get on our newsletter lists. We'll have lots of blasts as things come out. But what I do want to talk about is the Cal OSHA emergency standard. Now, this is something that has been in place for a little while, and when it first came out, it really turned things on its head. Employers were frustrated by the scope of what Cal OSHA was telling us we had to do, because it took the federal standard, which at the time was in place, and then it made it even more onerous in terms of protections and plans and all of that. We just got a little more clarification. I think it was the end of last week, something like that, to the scope, which has been helpful. And so I want to talk a little bit about that in terms of what we have to do. We have to have a COVID prevention program. So we need to have a plan in place for what we're going to do in instances of exposure, what we need to do in terms of notifying third parties. We're going to talk about the laws specifically requiring that in a few minutes, but you need to have a plan in place. You need to also provide PPE equipment. I need to offer to have testing or to pay for testing. So depending on the nature of your business is going to determine a little bit whether there's this need for ongoing testing or if it's just ad hoc, but we're going to pay for it. It'll depend, but it needs to be provided or made available to our employees. We also need to provide paid time off to our employees. Now this gets a little more complicated now that the FFCRA doesn't exist today. But what it means is if someone is exempted from the workplace because of a COVID exposure, we need to continue to maintain their seniority, their pay, and everything. At first, when we first got this, it seemed really overbroad and kind of confusing because there are lots of reasons why maybe that shouldn't feel like it applies. The clarification that we got a few days ago helps us with that. Because what it does is it it still says that it's COVID exposure, but it talks about a little more of the nuance. So for example, someone may be exposed, but they're able to do their work at home. That goes to that first bullet point. So it's not the reason that they've been excluded from the workplace is not to protect them from transmission. They can still do their job while they're at home. That's one thing, right? And then the other is if you're able to show as an employer that the individual did not acquire COVID in the workplace. That's a little tougher to show. We know from previous legislation in the state, and actually it was an executive order, I think, that started this, that there's a workers' compensation presumption that if someone acquires COVID, there's a presumption they got it in the workplace. Formatting got a little wonky here, but my apologies. So who has to be excluded? And the first thing is we have to exclude COVID cases. I'll run through this pretty quickly, but that's anyone who has a positive case and anyone who is subject to a related order to isolate. So someone says it, or someone who's died of COVID-19, obviously. Now, the question then becomes if there's been COVID-19 exposure. So that's if you've been exposed to someone who falls into one of those categories. Something just fell off my desk. If you've been exposed to one of those people, what you need to do with that. Now, exposure means that someone is within 6 feet of someone who is a COVID case for a cumulative total of 15 minutes in any 24-hour period. So what does that mean? Well, if you sit in a conference room with someone, you sit meet with someone in a cubicle, depending on your industry, whatever you're doing, if it's more than 15 minutes in a 24-hour period, they're subject to an exclusion. Now, the question then becomes how long are they excluded? And it's going to depend a little bit on whether they're asymptomatic or symptomatic. But ultimately, you kind of start that period from when they were exposed to someone 2 days before symptoms arise until 10 days after they appeared. That you're going to see on the next slide is mostly the same for people who you're excluding. If it's asymptomatic, it's 2 days before the first specimen was collected that led to the positive test to 10 days after. Now, what about returning to work? Similar concept, right? You need to make sure that 10 days have passed, and then you need to look at the symptoms. So there needs to be at least 24 hours since a fever of 100.4 degrees or higher have passed without having that fever and without the aid of fever-reducing medication. For asymptomatic employees, it's basically 10 days, right? It's after the specimen was taken, you have 10 days. An important note, though, and this is still the case with Cal OSHA, it's really important to note this, you cannot require a negative test to bring someone back into the workplace. There are a few reasons for that, but what the Cal OSHA guidance told us is we know that there are instances of folks who are, had COVID or had symptoms and they feel better, they're asymptomatic, but they just keep on having positive tests. And so the state said that there's a risk that there's going to be discrimination against those individuals. So we need to make sure that we nip that in the bud. We can't require a negative test. By the way, we're not really talking about this here because there wasn't legislation on it, but I want to touch briefly on vaccinations. The law tells us right now, from the EEOC, that employers are able to require vaccinations of their employees. However, I would caution against jumping directly to that, at least right now, for a few reasons. One, if someone holds a closely held religious belief, they are not required to abide by that. So there's going to be a lot of gray area there where people may say that they don't want to take a vaccine, and without questioning any wisdom of that, I'm just saying they're going to do it. And then the question is why, and then the question is if that opens up to some sort of protected class or activity or makes you privy to information you don't want to know. And the reason I say to particularly table it for now is most people can't get access to the vaccine right now anyway. So let's make sure that we're not putting ourselves into a box unnecessarily early. Again, that's kind of off topic a little bit, but it's very closely tangential to what we're talking about. Very briefly, the notification requirements. There are two pieces of legislation. First is AB 685. This one came into effect on September 1st, and it deals with if there is a potential or a notice of potential exposure to COVID. So that's if someone who was exposed to someone, you have to provide notice to 3 different groups as applicable. Employees who are at the work site during the infectious period, employee representatives, that could be like union members if you have a collective bargaining situation, and then employees of subcontracted employees. So if other people were coming to your work site. For your employees, and if you're going to union reps or to other representatives, you need to talk about A, they've been exposed, the benefits to which they might be entitled, and what you've done about it, what disinfection and safety protocols. For the employees of subcontracted employers, you don't need to talk about benefits because they're not entitled to benefits from you, but the other two requirements do apply. That's one day, right? So we've got one business day. Now we're going to move on. This is important. I have a colleague who talked about this, and she talked about 1, 2, 3, right? One business day, that's one thing. Now we go to 48 hours. So 2 days, not business days. So it happens on Friday. Sunday is 48 hours later, for example. This is if there's an outbreak. So this is if you have what's deemed an outbreak, and that's where in a non-healthcare setting, you have 3 or more lab confirmed cases of folks in different households, mind you, in a 2-week period. So if that's deemed an outbreak, you need to make sure that you're meeting the public health notification requirements. Okay, so that's 2 days. Now let's talk about SB 1159. This is 3 business days. This is notification to your workers' compensation carrier. Now I mentioned, or administrator. I mentioned a few minutes ago that there's a presumption that claims, or excuse me, that folks who come down with COVID-19 got it at work, but it's rebuttable. This dovetails with that. And by the way, this went into effect in September. So all of these are in effect, but this was earlier. And if within 3 business days, we're back to business days, of knowing that an employee is tested positive, you need to inform your workers' compensation carrier of the following: the test, when, and basically who was there and how many people were there and could have had access or could have had contact with those individuals. All right, I want to give a brief wage and hour update that has a few things. One slide, make sure your minimum wage increases went up. I would suspect, being in San Pedro, most of you have employees in the city of Los Angeles, so make sure that you're keeping in mind July 1st, 2021, we're going up to 15 an hour. Also the state requirements. This is more just for your benefit. We can talk about it if we have to. I want to talk about AB 5. Now, AB 5 is not a new thing, so I'm going to gloss over it, the general concepts pretty quickly in the interest of time. But this is a quote that we use a lot of times when we talk about AB 5, which is the independent contractor distinction, if you're not aware. And what the quote basically says is, look, laws, very often laws, especially complex ones, are written with what I would call soft edges, where they write the law, the legislatures do, and then we need to figure out exactly what the confines are. We need to, frankly, lobby around it. And that's exactly what's happened since AB 5 was passed. So in short, this is AB 5. There's a case called Dynamics that, putting it bluntly, eviscerated the independent contractor distinction here in the state of California. It took away this is a bit of an oversimplification, but by and large, in most instances, did away with what are called the Borrello factors, which is a prior case that looked at a number of things and balanced all the factors and created a new test, the ABC test. And the ABC test, you can see down there, A, B, and C, looks at 3 factors conjunctively, which means that all 3 of them must be met for someone to be an independent contractor. And if not, they are an employee. So what this did is across industries that don't have exemptions, and we'll talk about that in a minute, it killed this distinction for lots and lots and lots of employers. So all of this is to say, if you have independent contractors, this is not a new law, by the way. It's been on the books for a while, but it's still having those edges sorted out. Make sure you're looking at your independent contractors if you haven't already. It is, if not alarm bell number 1, it's close to it for us as employment attorneys. When we have clients who say, oh, well, that person's a contractor. I don't need to know much more to just flatly assume you're wrong, that it's probably not. So I say that, a bit hyperbolic, but not much. That's just the nature of the way it is. So keep that in mind. But I want to talk to you briefly about AB 2257. Now, what it did is it created a bunch more exemptions. And I've got them all listed off here. In the interest of time, I'm not going to go through each of them. I just want to have this on your radar. Depending on what your industry is, this new piece of legislation that went into effect in September of last year, so pretty recent, now creates a lot more exemptions. There are a lot more groups that spoke up and said, hey, we need to get a carve out. So we've got broadening of the business to business exemption. So that's if you hire a business. Or if you hire someone for a single engagement. So if you have someone come in to do a project for a day that might otherwise have been a little more in the gray area, we can more likely consider that to be an independent contract relationship. Also, just a number of other exemptions, referral agencies. We now know, for example, we dealt with youth sports coaches, things like that, that were going to be a nightmare to deal with. The legislature, in its infinite wisdom, cleaned up a bit of that. And then there's some miscellaneous ones. I'm not going to go through all of them because the chances of just hitting the nail on the head with one of you, relatively slim, but suffice to say that they exist. So in my last 10 minutes or so, I'm going to go through relatively rapid fire. I don't know, it's probably 6, 7, 8 cases that came out in the past year. So came out in 2020. 1 or 2 may have been in 2021, but new cases that we're seeing moving forward. And I want to talk about why they're important. Oh, and by the way, I should have mentioned this for AB 5, we had Prop 22. That's probably not news to you. That was the one that was pushed forward by Uber and Lyft and created an exemption for those drivers and had some slightly broader reaching implications to it. But it just kind of shows the process that's going to come into place. We're likely to see more ballot propositions like that moving forward, as well as legislation. So let's talk about a few cases. And I want to talk about these. When we say new laws, we have statutory law, right? That's what all these books are. Those are the laws that are written by the legislature, and they say, thou must do X, Y, and Z. There's also case law, and that's when courts evaluate things, and they look at the law, and then they interpret it. And so that's, we call that common law. It creates its own binding law, and that's very often what we're looking at as attorneys because it interprets laws as well. So this is important stuff. So I want to talk about Kim v. Raines, and the reason I want to talk about this is we're seeing lots and lots of what are called PAGA cases. PAGA cases, I can't talk about all of it in the next 9 minutes because that is impossible, but I want to say it's kind of like class action light. It's where someone can bring, without going through the full process of a class action, can step into the shoes of the attorney general and bring a claim against the company, usually for wage issues. So saying all similarly aggrieved employees, that just goes back a year from the date of filing, didn't get their meal breaks, didn't get their wage issued in the proper way. We're seeing tons and tons and tons of these. And previously, we would do through some machinations where we try to have arbitration agreements and try to use that as a way to arbitrate individual claims and stay the PAGA, so push that off and use that as leverage to settle. Kim v. Raines takes the wind out of those sails, and it gives the right to courts. It says that you don't need to, if you settle your individual claims, you can still have standing to pursue the PAGA claim, so we can't kind of eviscerate those on their own. And so a slight kick in the teeth for us. Barriga versus 99-cent only stores. This is more for if you're in class litigation. Very often we'll say, oh, we can get 100 people who will sign the same thing, and we'll say that all of them did whatever that's positive for the company. In this case, basically says, no, you shouldn't do that. It didn't, I won't go into exactly what happened in the case, but really there were like 174 declarations that were nearly identical. And when asked about it, the employees basically said, I don't even know what these are. I mean, I signed them, but didn't really get it. Court didn't like that. So if you're in a position where you're litigating a case, it's very important that we're being more specific as we deal with things. David versus Queen of the Valley Medical Center. This is a case that deals with imposing upon breaks, right? So very often when we have cases that say that the individual's rest break claims, the allegation is, well, I always got interrupted. So sure, I would take my lunch break, but my supervisor would walk in and say, hey, you got to come back to work early. And that's not allowed, by the way. But that's the allegation. But what this case did is it put a little bit nicer point on it. And it said, let's figure out or help figure out a bit more of where that line is, where, if the company has a good policy about receiving meal breaks, but, once in a while, someone pops in and asks a quick question to someone on break, that's not enough to say that they had a break that was improperly impeded by the employer. So it shows, one, that plaintiff's attorneys are getting more creative, but it also shows that we have some leverage that we can try to push back. Big picture, it means take a look at your rest break policies and your meal break policies. For those of you who have non-exempt employees, which is probably quite a few of you, if not all, and make sure that we're not getting in the way of our folks taking their breaks. It's really important that we do what we can to make sure we're staying compliant. Betancourt, now this is a case that's helpful for us, but I give these is good for us, but also to explain something a little bit more. In California employment cases, and this is bad news, and it's not new news, but it may be new news to some of you. The way cases work is there's very often an attorney's fees provision written into the law. So in California, we have the Fair Employment and Housing Act that deals with housing. We won't talk about that, but it deals with employment. So that it codifies, so it puts into statute provisions against harassment, discrimination, retaliation, those sorts of things. And what it says in those pieces of case law, it's somewhere in that book, it says that in the event that the plaintiff is a prevailing party, the plaintiff is entitled to recovery of his or her attorney's fees. Now, it only goes one way. So what does that mean? That means that you take a case and you go all the way to trial, and you get to trial and the jury says, I don't really see a big, huge issue here, but something may have gone wrong. So we're going to give the plaintiff $1. That feels like something, or a nominal. We'll give her $1,000, $10,000, something like small. What the jury doesn't know, and what the jury is not allowed to know, is that the next thing to hit that judge's desk is a request for all of the plaintiff's attorney's fees, which will be $500,000. And then, by the way, if we go to trial and we win, we get a pat on the back. We can't ask the plaintiff for his or her, or for him or her to pay our attorneys. So that just doesn't exist. It's a one-way fee shifting provision. Why is this? Well, in theory, it's because it allows for employers, or it incentivizes attorneys to bring small cases, right? If Joe Smith is underpaid at his minimum wage job and is getting, not getting $50 a week or $100 a week, well, that may not be big potatoes or that may be small potatoes to the attorney, but to Joe Smith, it's a big deal, right? That's a big chunk of his compensation that he's just getting hosed on. So the legislature says, okay, let's incentivize it. Attorneys, if you want to bring those cases, you can get your attorney's fees. So now, in reality, the plaintiff's bar has excellent lobbyists, and they write the laws, and they're written in that way. Nothing we can do about it. But we have cases like Betancourt. And Betancourt dealt with a rest break case. Now, we always say as attorneys, rest breaks are not wages. So because of that, the nature of the claim that can be made is if you have an unpaid wage claim, there's attorney fees provisions. If it's for penalties, which rest breaks would entail, it's not wages, and therefore attorney's fees are not recoverable. This case confirms that. We'd always argued it, but this case confirms it. So it's good for us. It's nice to have a little win, but I wanted to add it because it was a new case, but more because it was emblematic and an opportunity to share that information with you. It's not great news, but it's something you should know, because unfortunately we have to, Marette and I and our colleagues, we have to explain that to clients every day. Why are we settling this case? Well, because while everything can go right, you still have to convince 12 people in a jury that you did absolutely everything right. And if you can't, you get hit big. And that's a horrible, we call it legalized extortion. Cost of doing business in California, it's awful, but it is a reality. Okay, sorry, that one went a little long, but I think it's a helpful case and a helpful thing to talk about. This is an interesting case, Scalia, that dealt with, and this is something we see very often. Employers have, you may have a payroll company with whom we do work, or other, PEOs, different things where they're a little tangentially involved. Well, in this case, there was a lower level employee at the company that was using the payroll company. So the main company said, hey, payroll company, do X, Y, and Z. And it turned out what X, Y, and Z was, that was wrong. It was against the law. And the question was, can that decision that was communicated by a low-level employee who didn't really have ostensibly the authority, but it was communicated as if, I think it was a she, but he or she did, can that be imputed to the company? The answer is yes. So be careful. You want to make sure that if you're asking your vendors or your payroll people or your PEO or whatever you may be using to do something, you can't hide behind the shield of, it was the person at the bottom, Bart totem pole asked, and he or she didn't know better, but whoops, no harm, no foul. No, there is harm, and it's a big foul. So don't do that. Make sure you're paying attention. Okay, I think this is my last case that I'm going to talk about. And this is a case dealt with Apple stores, and there was a policy at Apple stores that when employees left for the day, they would clock out, and then they'd have to make sure that they got checked to ensure they weren't taking some AirPods with them. And the claim was that this actually took some time. And so we used to make this argument, coming and going, you're walking out the door, that shouldn't count. Well, here, what the court ultimately did, and I'm simplifying it a little bit, but it looked at the level of control. And it said that, hey, even though they're not working ostensibly, they're still being checked. They still have to be there. And so they're still under control. And so because of that, that time should have been paid. So this had a significant implication for Apple. And there are lots of ways that this could be extended to lots of different businesses. I mean, if there's just something that has to happen that your employees have to do at the end of their shift, and you see it as they clock out and they do it on their way out the door, that's not going to be enough. There was a case against Starbucks, I don't know, two years ago or so, that dealt with a very similar situation. It was an individual claimant, but it was a manager. And the manager said, may have had a representative side, but in any event, the manager said, okay, well, I clock out, I get that. But then after I clock out, I have to lock up the doors. We have a policy that if it's late at night, I have to walk other individuals back to their cars, make sure everyone's safe. And then is really when I'm off duty. And because of that, the court said, you're right. It got rid of what we would call de minimis violations. So we used to argue, 30 seconds here and there, does that really matter? No, it does. It does, and it counts. So when you go back to that concept of, you can have a small recovery, but then all those attorney's fees, we got to keep that in mind. So make sure that when our employees are under our control, we're paying them, okay? Last but not least, and I thought I was on my last one, but I was not. This is just a case that deals with commute time. So taking a step back, commute time, typically not compensated, right? Our time spent driving to work, driving home from work, we don't pay for that. We call it comings and goings, no problem. It gets a little more complicated if people have to drive farther away. So then you look at what their normal commute time and then what's extended beyond that. What this case did is it looked at a little more nuance to it. So this was a copier repairman, and in their trucks, it was their personal vehicles, and they went to customers' work sites, but they had all kinds of stuff. So they weren't paid for the time going to the first one or coming home from the last one, but they had all sorts of tools in their truck that could only be used for doing work for the company. And so ultimately, the company was incentivized, or the company wanted them to have that stuff in there because that allowed them to go more quickly and perform these calls. And, it looked at the idea that, well, the repairman wants to take his or her kid to soccer practice, can't, stuff in the back. And so it looked and it created a distinction. It's not as clear as we want it to be. In instances where it's a clear, you're driving to work. When I drive to work every day, or if I was a non-exempt employee, clearly I'm just driving to work. But if I had a bunch of stuff that I needed and all of that, it's not quite as clear. So take a look at what your employees do. If you have people who are going from place to place, don't have a traditional work site, don't have a traditional office work environment, make sure you're thinking through that policy. You're probably okay, but this is a case that heightens or brings to mind the fact that there can be a little bit of nuance. So that's the last of the cases. I went a couple minutes long. I saw a question pop up. What I'm going to do, I'll put this up because it has our contact information as well. And then let's stick around. We will be here as long as you'd like. And then I think at some point we may get kicked off. But if we do, call us, email us. We are happy to answer any questions you may have. I know this was absolute rapid fire, tons and tons and tons of information. We apologize for that, but we had to do the best. We could have made this 3 hours and bored you. Well, you're probably bored already, but could have been worse. So thank you for the time, and let's see what questions we have. I'm going to take a look at the chat, which I've not been doing.
I saw one question related to the mandated reporting requirements and whether it applies if the minors are not employees but are volunteers. And I looked it up real quickly while Ryan was speaking. So Penal Code section 11165, it defines child as just anyone under the age of 18. It doesn't say whether the child's an employee, whether it's a volunteer. So if there's a child at your work site, whether they're volunteering, whether you're paying them, these mandated reporting requirements apply.
Yeah, and by and large, too, in employment issues, now there can be distinctions between employees and volunteers, and that's important to keep in mind. If your defense to, well, I didn't report that child was being abused because it was just a volunteer, not great, but also just generally, typically better to overdo it than underdo it. So just keep that in mind as you're abiding by things. You know, the law sets the standard, but there aren't many situations in which going above the law is going to get you in trouble. Off the top of my head, I can't think of any. I'm sure if I really thought about it, there might be, but let's pause. We got a question here. Does the passage of Prop 22 overrule AB5? It does not. So what it does, and that's a great question, we have AB5, which creates the ABC test. And that looks at control, that looks at the type of industry, that looks at whether they're dedicated to that type of work. And what Prop 22 does is it created another exemption. So, you know, in the initial iteration of AB5, we had exemptions for, professional exemptions. There are certain things that applied. The way we talked about it, and this became the buzzword, is it was whoever had the lobbying juice to protect themselves. And Uber and Lyft were seen as a big fish that the legislature kind of wanted to go after, potentially. Oh, sorry, I should have stopped sharing. Thank you for whoever helped me with that. But Uber and Lyft obviously have a lot of money, and so they were able to get the right things going, to get the right proposition on the ballot, and then obviously we, as a state, at the meta level, voted for it. And so it creates another exemption for ride share type things, a little more broadly than just drivers, but it's pretty narrow. So we've got a question about sick time, Los Angeles versus California. So sick leave pay is required in the state of California. It's 24 hours in the state, and then there's a requirement for the city of Los Angeles. And I don't know off the top of my head what the hours are. I'd have to check. And the reason I say that is because I advise lots of different cities, and I don't want to just say it to you and be wrong. Moret, do you happen to know off the top of your head Los Angeles? If not, what I can do, it's very easy to find, and I'll talk about it in the bubble. Do you know, Moret, by chance?
No, I think San Diego was like 40 off the bat. It was either 30 or 40, but each city kind of can vary. So you got to look at like specific ordinances.
Yeah, I think that LA is 40 hours of sick time pay. I'm not positive, but if you just look it up, that's the number, that's the amount of time. Now, this is probably more nuanced than you wanted, Melissa, so I will just say it briefly, and if we have more questions, there are different ways you can do it in terms of front loading or having it on a rolling basis. That is a big, long conversation, but suffice to say for all employers on here that if you're not providing sick pay, it's been in place for a while and you should be. So yeah. Any other questions? So we got a question from Ross, and I will be blunt. I don't know much about this. It's the question. I think everyone can see it. I'm talking about the Cal Slavers legislation, which requires employees to provide a retirement plan or auto-enroll the employee. That's a little bit tangential to employment law because it's getting a little more into. So, Ross, would you like to talk about it? I mean, it's not.
This is Elise, and we have a request into the state, the group that's providing those presentations, to do a presentation specifically on that program. Yes.
I wish I could tell you. It's just a little out of our wheelhouse, and the last thing I want to do is just talk to talk. So appreciate the question. Good luck to you. So there's a question about COVID-19. It's technically from September. So that's SB 1159. It was from September of last year as opposed to I'm getting all my numbers mixed up, but the notice requirement for employers on 1 or 2 days came into effect on January 1st. All of them are in place right now. And by the way, keep in mind that things change and we may see federal guidance on this stuff.
Excellent. Thank you, Ryan and Moret. Great presentation. Any other questions before we close things out? Simply really good info and another example of why the Chamber delivers some quality content. So thank you so much for both Ryan and Moret, and Elise and Laura for making today happen. Thank you, everyone. Did you have anything else you wanted to say, Elise?
No, I think that's good, but Ryan and Marette, you are available if people think of more specific questions after maybe reviewing the slides, because we will share them. I know I have some COVID related questions that I'm thinking through, but I want to look at your slides again. So if you get us the questions, we can get those over to Ryan and Marette if something else comes to mind. But thank you, everyone.
Thank you, everyone. Be well.
Thank you.
Take care.
Thank you, appreciate it.